the Child Care and Protection Act, Section 68, remand or committal to juvenile remand center. Okay, let's see what this is about. Subsection 1. Any court on remanding or committing for trial a child who is not released on bail shall commit that child to custody in a juvenile remand center named in the commitment, to be detained there for the period for which the child is remanded or until the child is there delivered in due course of law, provided that in the case of a child who has attained the age of 14 years, A, the court shall not be obliged so to commit that child if the court certifies that the child is of 1, so unruly a character that the child cannot safely be so committed, or 2, so depraved a character that the child is not a fit person to be detained. So here it says, if the child is more than 14 years old, provided that a child who has attained the age of 18 years, of 14 years, the court shall not be obliged so to commit that child. Okay, so if a child is more than 14 and is of very depraved, unruly character, then the court may choose not to commit that child to a juvenile remand center. Alright, let's see part B. Provided that the child has attained the age of 18 years, where the court so certifies, the child may be committed to such place, including an adult correctional center, as may be specified in the commitment warrant. So the court can place a child who is more than 14 years in the adult correctional center. Alright, let's see, this is subsection 2. Subject to subsection 3, the court which makes an order under subsection 1 committing a child to custody may on application A, vary the order, okay, or B, revoke the order in respect of a child referred to in the proviso to subsection 1. Subsection 3. If an application under subsection 2 cannot conveniently be made to the court which made the order for commitment, action under that subsection may be taken by any court having jurisdiction in the place where the sitting of the court which made the order was held. So here, so it can be any court, right? Any court can make that order, right? Subsection 4. If the order is revoked, the child may be committed to such place, including an adult correctional center, as may be specified in the commitment warrant. And it's probably that child having attained the age of 14 years and is such unruly and depraved character, probably is posing a danger to other children in the remand center. So they move that child to the adult correctional center. Section 69. Attendance at court by parent of child charged with offense, etc. Subsection 1. When a child is charged with any offense or is for any other reason brought before a court, the child's parent or guardian may in any case and shall, if such parent or guardian can be found and resides within a reasonable distance, be required required to attend the court before which the case is heard or determined during all the stages of the proceedings, unless the court is satisfied that it would be unreasonable to require his attendance. So if your child is brought before the court, you are required to be present in the court during the proceedings of the court. Unless, of course, such is unreasonable. Maybe you're living overseas or you're sick. Alright? Subsection 2. Where a child is arrested or taken to a juvenile remand center, the officer or sub-officer of police in charge of the police station in the district of the court before which the child will appear shall cause the parent or guardian of that child, if he can be found, to be warned to attend court. Okay, so you must attend court. As long as they can find you, you're the parent of a child being brought before the juvenile correction, the children's court. Alright, juvenile remand center. For the purpose of enforcing the attendance of a parent or guardian and enabling him to take part in the proceedings and enabling orders to be made against him. A summons may be issued and served on him requiring attendance before the court, and the provisions of the Justices of the Peace Jurisdiction Act shall, with the necessary adaptations and modifications, apply to the proceedings on such summons. So your child being brought before the Juvenile Correctional Center, you may be summoned to attend the proceeding. Subsection 4. The parent or guardian whose attendance is required under this section shall be the parent or guardian having the actual possession and control of the child. Okay, so if you don't have legal custody, then you might not be required to attend, provided that the attendance of such parent shall not be required if the child is, prior to the institution of the proceedings, removed from the parent's custody or charge by an order of a court. Okay, so if the court took the child from you, right, from your custody, you don't have custody of the child anymore, and then the child is brought before the court, you might not be summoned to attend court, although probably your presence would be useful, but you cannot be forced to attend the court under such circumstances. Alright, so we'll look at section 70 in our next video.